Are you ready?
Yes, good afternoon, Deputy Chief Justice and Commissioners.
Good
Thank you.
afternoon to you too. I would like you to tell us briefly, in your own words, what qualifies you for this job.
I have firstly more than 27 years experience in the legal profession. The last 20 and a half years has been spent as magistrate and regional court magistrate in the Western Cape. And I have a very strong background in civil, particularly civil work and civil procedure. But I'm also well-rounded in that I've appeared as an attorney in criminal matters, and insofar as my judicial experience is concerned, I've presided in criminal matters. And I bring to the bench, if I am fortunate enough to be recommended, good work ethic. I am independent, I'm impartial, I strive to be extremely fair to all litigants, and I've played a huge role in judicial education in the Western Cape, particularly in the Western Cape Regional Division. And that experience has assisted me in contributing to transformation in the lower court judiciary. So I do bring a lot of experience, and I have the necessary integrity for a position to be elevated to the Western Cape High Court bench. And I also have to point out that one of the important aspects for me in the course of my career as a judicial officer especially has been access to justice. And in my role, particularly in the Western Cape Regional Division, together with two colleagues at the time, being called upon by the Regional Court President in 2010, when civil and divorce jurisdiction was conferred on the regional courts in the country really. I, along with two colleagues, spearheaded and assisted the Regional Court President in bringing the regional courts to the various areas in the Western Cape. So I'm a fit and proper person, and I took a decision to apply for this position, and I believe and I hope that I am ready for a position elevated to the Western Cape High Court bench. I have also served 3 full terms during the course of last year.
You were an attorney for 5 years before becoming a magistrate.
Almost 5 years. I think it's 4 years and 7.
Close to 5.
Yeah,
just
close
under 5.
to 5 years. That's correct.
And you were according to my arithmetic, you were a district court magistrate for 8 years before you went to the regional court in 2010.
Yes, I was appointed Deputy Chief Justice on the 6th of May 2002 as District Court Magistrate at the Wynberg Magistrates Court.
And you mentioned a wide range of civil work during your stint in the District Court.
Yes.
So you've been a regional court magistrate for 12 years?
If you count my acting period, and I took my acting stint from the date of the Minister of Justice appointment, which was 1 August 2016, that is from the permanent appointment, but I started acting in August 2010, so you are correct. It's, I think, slightly over 12 years now.
All right.
In total.
Okay. You're an alumnus of UCT and UWC.
That's correct. Because I did BA with law subjects, I therefore was only required to do the 2-year LLB at UWC.
When did you start acting in the High Court?
I acted from January, the first term of 2021, first, second, and third terms, the full.
So January
full
until September.
Yes, I think the last day was the 17th of September.
And how many written judgments were you able to produce during that time?
I produced 40 written judgments of my own. I recall, and when I did my statistics for purposes of my questionnaire as well as the upcoming interview, there are 2 judgments. I can't take credit for that. Those are 2 judgments written together with 2 of the senior judges in appeals, so I've not counted that in the 40 written judgments.
But you should, because I would imagine that you participated fully in those proceedings and the writing of the judgment.
All right, thank you for enlightening me, because I wasn't sure if I should add those 2 as well. And I've checked, and my understanding is that in the 3 terms, I have 5 reported judgments.
You know, it has been a bit of a challenge for me to follow your trajectory on the papers, because most of the things are set out in a CV at the back, and the application form, which should actually be where we find all the material stuff, is a bit thin. Now, you have listed 4 judgments which you delivered outside.
Yes.
The 3-month period, but on my count, it was just a period of about 4 months, which is still within, well, not within the norms, but it's still acceptable. But why did you exceed the 3 months?
I'm going to, if I could just be given an opportunity. Deputy Chief Justice, I type all my own judgments, so I use the Dragon the Dragon software. And so I do the typing and the editing all myself. I was fortunate to have 2 registrars last year, the one registrar for the first 2 terms and then another registrar for the other term. But when it came to my judgments, they didn't type my judgments and edit it. I would type it, edit it, and I would send it to them to do the headings. And with particularly the matter of REDISA, it's the Recycling and Economic Development Initiative versus Tubestone. That was the longest, that was 25 days after the 3 months. And the trustees for the time being of the Birmingham Trust. Those are 2 reported judgments. So I found those, I needed to do quite a lot of research, even though I had very good heads of argument in the matter. They were challenging aspects that I needed to deal with. And the JVE Civils matter, the record was in Afrikaans, it was engineering. So I needed to, actually, I sat with Google Translate in certain circumstances. So it has been I suppose, an administrative together with a research aspect. That's why those were delayed. I can also inform you, Deputy Chief Justice, as I've indicated, I think in the one judgment, I indicated in the judgment the reason for the delay right at the end. And in respect of the others, the communication was sent to the respective legal practitioners that there is a delay. So that is the reason. I must also add that I believe in taking responsibility, so I have disclosed all of this in my questionnaire.
You mentioned one reserve judgment in your application form. That would be in the regional court.
No, that was my last High Court matter, and...
Were you still at the High Court in May of 2022? I thought you... You were there until September
No,
2021?
it was a parted.
Oh,
Yeah, it was
yeah.
a parted. I had to go back to the regional court. I think it was the end of last year, and then they filed the heads in. I can't recall. I think it was in April. No, they filed the heads on the 23rd of May, and I was already back in the regional court. So I worked on the matter, typing, researching, etc., while I was in the regional court, and that was delivered. That was also a delayed judgment by, I think. In my letter that I sent this weekend, that was 16 days. It was sorry, not 16 days. It was a 16-day trial.
Yes. You submitted a memo responding to the misgivings some of the
Yes.
law bodies who sent their submissions on your suitability as a candidate
Yes,
expressed. Do you want to, well, in the main, being that you still need more acting experience, you don't have nearly enough experience as yet, and the other concerns related to, well, in allegations that you had not shown any affinity, as they call it, to develop
Yes.
young practitioners, and you were accused of not advancing transformation in the judiciary, making controversial judgments against the judiciary, and having a knack for recommending disciplinary actions against practitioners instead of adopting a fair-minded and nurturing approach. Well, you know what they are.
yes.
Do you want to just take us through your
Sure.
response, but briefly?
Briefly, very
Yes,
well.
please.
So, to start, that I've explained in this letter, which I addressed this weekend, that I'd only received these letters on Monday, the 3rd of October. So the main, I think the main one is the one from, I think there are two letters from the Black Lawyers Association. The first one, they say that I acted for 3 full terms, and at the end of their letter, which is the first one in this bundle, they then come to the conclusion, or they conclude that they are of the opinion that I'm just short of the minimum 3 terms, and that I should be given an opportunity to act, and so they don't support my nomination.
At this stage?
Yes, at this point, they say. So in my letter, I have dealt with it at paragraph A1, where I indicate that I can confirm that I acted for 3 full terms, and I also indicate that, of course, one is invited by the judge president to act. I deal with a variety of cases that I heard, and at the end or conclusion of the second paragraph on A1, I indicate that I delivered 40 written judgments, of which 5 were reported. To the best of my knowledge, none has been overturned on appeal yet, and I indicate there that I am more than ready for elevation to the High Court bench. The second one, which, with the greatest of respect, I found a bit, I don't know, concerning. It's the second letter dated the 29th of August, and that's the second letter in this bundle, and that I have dealt with step by step. So I was very concerned to read that, according to the BLA, they say, according to their observations, I have not demonstrated any affinity to develop young practitioners and advance, advance the agenda of transformation. So on the issue, on their observations, so firstly, I'm a bit unclear because that's not clarified in the letter, and I mean that with the greatest of respect to the BLA. I deal with my experience over 20 and a half years, and I say very specifically that as as previously a practitioner from the Cape Flats, so specifically the Athlone area, I did my articles at Legal Aid, so I was a public defender. And I set out, in my view, how I have provided feedback over the years to attorneys. I share law updates. I send amendments of legislation. I provide comment on any relevant cases. And I continue this. This is a continuous practice that I do still to this day. And quite importantly, that I do not need any prompting in expressing encouragement to practitioners. And I've on more than one occasion informed practitioners who I've been particularly impressed with to consider joining the Cape Bar. And some have in fact taken my advice. So years later, people inform me, I used to appear before you in motion court. I would inform them that I'm particularly impressed by their pleadings, whatever, and it's a continuous thing. And when I came to the High Court, I just need to say this. I had in fact received telephone calls from young advocates who had phoned me to welcome me to the High Court. One had reminded me that he used to be an attorney who used to practice, and I had encouraged him to consider going to the bar. And what I then set out is, if I were asked, and you have asked me to be quick about it, but I would be prepared to give very recent examples of where I've done this in the regional court a few weeks ago. So I must...
Well, sorry, when you say encourage, what do you mean? How do you encourage them?
Deputy Chief Justice, I'll need to give you examples. So I preside currently in a civil regional court in the Bellville Regional Court. If I see people who have drafted really good pleadings, who've done an application and have really shown me that they are motivated, they are encouraged to work, and I'm speaking about relatively young practitioners, I feel, and I've always had this view, that they need if I could put it very colloquially, a thumbs up. They're doing a good job, in my view. Whether they ultimately, the matter is, whatever the outcome, I'm not going to tell them on the day. So that is how I have expressed encouragement. I think the BLA uses the word nurture. I prefer to use the word encouragement, because I believe if you have an attorney or candidate attorney, because it's not limited to attorneys, I would inform them.
I suspect the real concern is that you have not mentored anyone.
Well, as a magistrate,
you have not transferred the experience, the skills you have to the upcoming generation.
Well, I am a magistrate. I'm not sure if I could actually mentor an attorney. What I have done, and I think that comes to the next point, is my involvement in legal education, informally and with SARJ, and where I give back to magistrates, aspirant regional magistrates, my experience, civil, matrimonial law, and this also is a continuous, it's a continuous thing that I do. And I remark at paragraph 3, for example, on my comment page, that I have as recently as I think it's the 22nd of May, I assisted with training in PAL of aspirant regional magistrates. Present at that was in the new Chief Magistrate of Cape Town and the acting regional court president. I think she's currently acting in the High Court. And they had participated in the sense that they were part of the people that I trained on that day in civil and matrimonial matters. So I'm not entirely sure if I can, as a magistrate or regional court magistrate, take attorneys essentially under my wing and mentor them in that way. I have suggested to practitioners sometime that I would contact the, the Legal Practice Council to maybe hold a workshop, or particularly with matters involving, with matrimonial matters. I find sometimes that's a bit of a problem for some practitioners. But this is how I have given back in my own way, and because I was also an attorney.
Well, the concerns raised about judgments you've written against the judiciary and the disciplinary inquiries that you are alleged to have recommended against practitioners, you do not have to address us on those because there are no details. One does not know what they refer to.
Thank you.
And I think that the references to your delayed judgments were covered when I asked you about the 4 you had listed. Well, I think those are the ones to which they refer.
Yes, yes. I had to, of course, in this letter, because the LSSA spoke about 2 outstanding judgments, and I had to, at paragraph B on page 5 of my letter, I indicated that I only had the one. That is the matter of Heinrich versus de Surf, and that is a judgment I delivered in September. I think it's a 52-page judgment on a civil trial. I've just received an application for leave to appeal in that matter, but I have no outstanding High Court judgments, no parties.
And in some, you say you have acted long enough to be permanently appointed.
I would say yes, Deputy
Well,
Chief.
you have sufficient experience.
Yes, I don't know if you wish me to expand, but I would say yes, I do.
All right. I'm going to hand over to the rest of the commissioners.
Sure.
Judge President Hlope.
Thank you very much, Deputy Chief Justice. I have no questions for this candidate. Thank you.
Thank you, Judge President. Mr. Boshoff?
Thank you, Deputy Chief Justice, and afternoon, Ms. Pangarker.
Good afternoon.
I just have 2 questions. The one relates to the Botha matter.
Yes.
In which that went all the way to the SCA.
Yes.
And involved you personally as magistrate. Would you mind just briefly explaining to the court how it ended up in the SCA and...
Not the court.
Oh,
To the commission.
I'm
Mr.
sorry,
Boshoff.
I'm late in the day. Apologies, everybody. Just to the commission, about the matter and how it ended up in the SCA, and ultimately how your conduct as magistrate was considered and treated.
Very well. Mr. Boso, sorry, Commissioner, it's a long story, so I am going to condense it. Yes. So I was an acting regional court magistrate in Cape Town when this matter came before me. It was a defended divorce. It was a divorce trial. I'm going to call Mrs. Botha was the defendant. Parties were married out of community or property. Mr. Botha was the plaintiff. And the matter, by the time it came to me, if I'm not mistaken, was already a 2008 case. It came to me in 2011. And several postponements had already been granted to Mr. Botha for legal representation. The unfortunate thing was that by that time, every time he has a new legal practitioner. The matter was then postponed. Mrs. Botha was represented by an attorney and an advocate who's a few years ago an SC. And what then transpired was the matter was postponed several months in advance, about 3 months in advance, and it was postponed final for trial for a period of 2 days. It would run over 2 days. In that time, Mr. Botha had then complained about me to the Department of Justice. I had to address a letter to my regional court president addressing the complaint, and I was vindicated in that complaint. And the attorney in this matter then phoned me and telephonically requested a postponement. I informed the attorney, you need to communicate with the legal representatives on the other side. That was not done. And an email was then sent, which is referred to by the Supreme Court of Appeal. What eventually happened is something I think I wouldn't wish on any magistrate or judicial officer. At that stage, I was already a magistrate for 10 years, and Mr. Botha was advised by his attorney to come to court to read a recusal application into the record and to then leave without participating in the trial. There was no request for a postponement. I explained, I think on 5 occasions, the consequences. I had practically begged Mr. Botha to stay in the courtroom. He was persistent that he's going to follow on his attorney's instructions. I explained all the consequences to him as is set out in the SCA, and eventually he read it into the record, confirming he knows the consequences, and he left the courtroom. I proceeded to hear the recusal, which I eventually, in a longish judgment, I then refused the recusal application. The trial then proceeded in the absence of Mr. Botha, and it followed on to the next day, and still Mr. Botha and his attorney failed to come to court. I gave an extempore judgment. I granted partial forfeiture, and I actually did not grant a cost order against Mr. Botha. The next thing, I was taken on review. There were very scurrilous allegations made against me. My integrity was attacked. My conduct in the court as a magistrate was attacked. And that without the practitioner having regard to the actual proceedings in the court. I made a decision then to oppose the review as a magistrate in light of that. And the matter went to the High Court. And eventually, I think it was 2013, I can't remember when, the review was argued, and the review was upheld, and as you can see, the High Court then granted an order in terms of which Mr. Botha and I were to pay the costs. I then had a cost order against me as a magistrate, and after taking some time to consider it, and during the period of the appeal, I decided that I could not continue with the cost order. I got advice, and the only thing that was left was to petition the Supreme Court of Appeal, which I did, and that was the judgment. So both as litigant and as magistrate, the Supreme Court of Appeal then vindicated me, not only insofar as my conduct in the divorce proceedings, but also in opposing a review, and opposing a review in circumstances where it was reasonable to do so, and I had acted objectively in opposing the review. And that's, this is a reported judgment.
Thank you very much. Then just a final question, technical question that I ask all the candidates. Could you please just explain to the Commission how you understand what you understand under the appealability of interim orders, and what approach a court should take when either considering an application for leave to appeal of its own interim order or considering an appeal as such?
Am I allowed to look at a judgment where I dealt with this?
You may remind yourself, if you
yes,
have it right
yeah.
there.
Okay, I have it in the other file.
So we can assume that you don't have the answer off the
Well,
top of your head.
Very well.
While you look up the case.
Apologies. Strictly speaking, the interim order can't be appealed. It has to have, an order which is to be appealed has to have a final effect. That would be my answer. I can't at this stage refer to the judgment.
Okay.
Yes. And then just following up on that then, are you familiar with a fairly recent, about a month old now, judgment of the Constitutional Court which dealt with that very question? It's the matter of UDM and another v. Lebashe Investment Group. Are you familiar with that judgment?
No, I must be very honest with you, I'm not familiar with the judgment.
All right, and where the court then essentially moved away from the tests, the strict test of finality, and emphasized the question of interest of justice as being determinative of whether or not an interim order is indeed appealable.
Thank you, Mr. Boshoff. I have to admit, I'm not aware of the judgment.
All right. I have no further questions, DCJ. Thank you for your time.
Thank you, Mr.
Thank you,
Bishop.
Commissioner.
Jackie Mlambo.
Thank you very much, DCJ. Good afternoon, Ms. Pangarker.
Good afternoon, Judge President.
You are still a regional court magistrate, am I correct?
I am a regional court magistrate, correct?
And
yes.
are you back there? Are you still acting in the High Court?
No, I only acted for the 3 terms from January to 17 September last year, and I wasn't invited to act again.
Okay.
So I am back in my permanent post in the region.
As we speak, do you have part-head trials in the regional court?
I do have parted trials. I have 5 civil parted trials. I know 2 are coming close to an end, and I have 4 or 5 criminal parteds. 3 of them are coming to an end.
I see. 3 of them are coming to an
Yeah,
end.
in the sense that we are almost done with the defense case. I think the one is actually already postponed for closing argument.
And the other 2?
The other 2, there's one where
How long are they part-head, those 2?
the one is actually a matter where the defense obtained a medical report very late. That I can't speak much about it, but it relates to the accused defense in the matter. And then they had applied to recall a particular witness. I think the accused is in custody for quite some time, but that matter, as well as the other one, wherever I have a gap, I place that matter on my court roll, even if it's after my civil roll and it's 11 o'clock or 2 o'clock. So Judge President, I can't give you specific times. I'd be lying if I told you, but both accused are in custody.
Why is it at any given point in time regional magistrates have these part-heads that are long outstanding?
May I just inquire, Judge President, are you speaking about a criminal particularly?
Criminal.
Because I think, particularly in the 2 that I have, the one where there was an application to reopen, that...
I'm not seeking for details of the cases. I'm just trying to explore why we have this situation.
I think because, unlike civil, there are a lot of role players in a criminal court matter. Besides the magistrate, you have the prosecutor, you have the defense attorney, you have and in both matters, interpreters. The one had a foreign interpreter, and then the witnesses. And specifically with regard to those two, I get the matters, I find space on my civil roll to do it so that we are continuously trying to get to a point where we are going to finalize. And I've recently, in fact, when I come back now, there's a civil trial of mine that has fallen flat. They are settling. And I've requested the prosecutor and the advocate that we heard that parted early in the morning as opposed to 2 o'clock when we would have heard it.
So you say one of the major reasons is because of the number of role players, but even high court judges run criminal trials. But you won't find a high court judge straddling so many part-head criminal trials.
I think what transpired was that I had swapped courts, so I was in a criminal court. I swapped courts with a colleague of mine, and I'm in the civil court. And so it works in the following way, where each regional court has 2 prosecutors. So I can only use the prosecutors when they're not, for example, in the other court. But we have made inroads, and we're trying to squeeze things in, and like I said, we're getting near the end.
Okay,
As far as we possibly can.
okay, thank you. Thank you, DCJ.
Thank you, Judge.
May I ask for a follow-up on this question?
Yes, Commissioner Matthews?
Look, I'm troubled by your response here.
Sure.
How many criminal cases that are outstanding as part-head matters?
I have, on my last stats, before I went on leave last week, I have 5 criminal parties.
There are 5.
5.
Out of these 5 outstanding criminal matters, how many of them are the accused still in custody where bail has been refused?
Three. On my recollection, sitting here, 3 are in custody. Bail was refused. In fact, the one did not apply for bail in the district court.
And how long has these matters been outstanding?
Commissioner, may I ask a question of clarity from you?
Yes, I mean, when did you start trial, and how long these accused persons have been in jail whilst the matter is not finalized? That's the essence of my question.
I can't give you exact dates when I started each of these trials. That's my first response on that.
Yeah, but that is important to me to determine, to understand exactly. Could it have been 4 years?
No.
3 years, a year?
No.
How old are these
The
matters?
longest one, I would say, started not last year, the year before, so that would make us 2020. And that was because we had started the trial, and there was a change of legal representation more than once.
Yeah.
That was the longest of them.
And whilst you have these matters, pending matters, I mean partly-head matters, in
Yes.
which the accused are in custody, they have been denied bail, you take up an acting appointment out of, since you spend time, was it 6 weeks, where you are acting. What was your plan in respect of these matters when you were acting?
Firstly, every time a term was concluded, I go back to the regional courts for my parterds. And that happened throughout that 3 terms that I acted. So the magistrate who acted in my space while I was acting in the High Court, so that was a district court magistrate, that magistrate went back to her district court. I come back to my regional court. I had no other matters on my regional court roll but my parterds and any new matters and any warrants which came in. So I did not stay in the High Court. That is why I think earlier I mentioned I would work in the regional court and I'd be working on. So I came back every recess period. to do my part is.
CJ, it was with your permission, because that to me is very important.
please go ahead.
My point is this: you take up an acting appointment, of which you could have just declined, because we have matters where accused are in custody. What is your sense of justice and the accused's right to a speedy finalization of their matters in circumstances where their bail admittedly has been denied? What is your sense of justice and fairness?
Very well. I'm very cognizant of the accused's rights in terms of the Constitution, the right to speedy trial, the Section 35 rights. And I did what I could do in order to expedite matters, and I'm still doing what I can do in order to expedite matters insofar as these accused are concerned. One of the accused, I think the one who was longest, I had almost insisted, because there was a question about, and I think those are 9 charges, there was a question about whether there would be a new application or an application for bail. And every time, I think on 2 or 3 occasions, when the matter's before me, I'd asked the particular advocate, because he had an attorney and then he changed legal representation, are you bringing a bail application? And they did not do that. So, Commissioner, I am cognizant and I have taken the steps to expedite these matters, have it heard while I was acting, and as I've indicated earlier, so every recess I come back and these things are continuously heard. But it's not only the magistrate. There are other role players as well involved in the matter.
Yeah, I mean, I think this is my last. You see, my difficulty with you, first when J.P. Mlambo asks you a question, how many criminal matters outstanding? You don't know. You simply say about 4 or 5. When you ask a question, at what stages are these matters? You don't know. And now you go and take an acting appointment, no clear, when the accused person is in custody, you don't tell us what was happening. I will argue at the end of this, during deliberation, that you have no sense of justice. Everything is all about you. People are in jail, you don't proceed with their matter. All what you do, you go and act. Thank you, Sir.
All right, I hear what you say. I think I have explained myself and expressed myself. I respect your view on it.
Thank you, Commissioner Nokies. Commissioner Marumahai.
Thank you very much, DCG. I'm here, ma'am.
Oh, sorry,
Good afternoon.
Afternoon.
The fact that you are a magistrate leads me to ask a question which I think it is a problem across South Africa. But I've read certain judgments specifically from the Western Cape, where judges lament the fact that the reviews, special reviews and automatic reviews, Section 304, 305, those kind of sections of the Criminal Procedure Act, when they are brought to the High Court, and then the 2 judges of the High Court refer the matter back to the magistrates with a query for them to clarify certain aspects. And you find that magistrates sometimes they take their time to respond to those queries. And at that time, you find that some of the accused might actually be in custody. But secondly, and most concerning, the responses that are provided back are not satisfactory. In your experience as a magistrate, have you encountered this? First of all, is this a problem at all? And if it is, in your experience as a magistrate, have you encountered this thing? What causes it in line with or having regard to the constitutional rights that are implicated?
So if I understand the question, is it a problem? Firstly, when I acted in the High Court, I myself addressed 3 queries to magistrates in 3 review matters. I did not receive a satisfactory explanation back in respect of one matter. And I think sometimes one of the problems is that, and I'm speaking generally, sometimes the question is not properly read within the context of the judgment that is being sent on review, because the judge's query is very specific, and the magistrate is requested to respond to that. So, yes, it is a problem. I encountered it while I acted, that I received something back and it was not actually a response to the question I had asked. Insofar as have I encountered it, if that question is, have I encountered it as a magistrate being queried by a judge? No, I have not encountered it. If the question is, have I encountered it as an acting judge? Then, with regard to my previous answer, yes, I have, as an acting judge, queried magistrates insofar as those reviews are concerned. And I agree with you, because you have the accused constitutional rights in the time, and I think there have been quite a number of judgments which indicate that there has to be a speedy response to those judgments. So it is a problem, and I think the problem should be addressed in the sense of this very specific question should be answered.
I guess, let me just crystallize my question. Do you, as magistrates at that level, either at the regional court or district court, in your meetings, discuss this thing? Because if you are having judgments, especially in your province, where judges identify this as a problem, and they express their misgivings about this particular issue, do you, at the magistrate level, have meetings about this and try to make sure that at least you do better, so that the rights of the accused can actually be protected?
I can only at this stage, Commissioner, address you insofar as the regional court is concerned. So, I have never been part of a meeting where that is discussed. My understanding, particularly with regard to those automatic reviews, those are matters for the district court. I can't, as I sit here, and I think it would be wrong of me to say the district court has meetings, or they do not have meetings, because I'm not a district court magistrate, so I can't address that.
No, I accept that. It's fine. Thank you very much, DCJ.
Thank you.
Thank you, Commissioner. Commissioner Makonish.
No, thank you very much, Deputy Chief Justice. Good afternoon, ma'am.
Good
This side.
afternoon.
This side.
Oh, thank you. Oh, sorry.
No, I have only one question for you, because I think I have to repeat it, because I've asked it to other members. What is the difference between in consultation and after consultation?
Sorry, I didn't hear you.
What is the difference between in consultation and after consultation?
In consultation and after consultation.
Yes.
I'm not sure. If it's with reference to legal practitioners, then I think, no, I think if I'm going to respond, I'll probably be wrong.
Can I also follow up, DCJ, on this point?
Yes, Commissioner.
Thank you. I think the point that is really being asked is where a statute says, as an example, the president may take a decision to dissolve the JSC after consultation with the Minister of Justice, or it says the president may dissolve the JSC in consultation with the Minister of Justice, whether you appreciate any distinction there.
I think it's
All right.
do you mind if I?
Yeah, please,
respond?
please, yes.
If it's, the president may take a decision after consultation, I'll start there, then it means that before a decision is taken by the president, that consultation must have happened.
Yes, correct. And then the same statute says the president may take a decision to dissolve the JSC in consultation with the Minister of Justice. How does that differ to the first answer?
I think, and I speak under correction, that would mean that the actual decision has to almost happen jointly.
So in other words, the Minister of Justice must consent. He has a veto.
I don't know if it's a consent. I don't know if I'd go as far as consent, but I would have to say an agreement.
Yes.
I
think
would rather
consent-
say an agreement, because a consent, in my understanding, would mean, let's say X is saying something and Y is here. X has already made his mind up about whatever it is.
Yes.
Y then consent. So that for me would be, the in consultation would be together or simultaneously, if I could put it that way.
Yes. In almost like in concurrence.
Yes,
Yes, or with the concurrence.
yes.
All right, well, that's the correct answer, but it's taken us a while to get there, which takes me to another question about your grasp of constitutional law principles. You know, this judgment that you've referred to here in your response, which you said you think the BLA is talking about the Ulu judgment. You remember that?
Yes.
Yes. Now, I'm not particularly interested in the complaint that you referred a practitioner to the disciplinary proceedings. I think a judge is entitled to make that call. So the criticism against you there, I personally think, is a bit unfair. What I do want to ask you, though, about is the jurisprudential logic of the judgment. My understanding of the basic facts there is that you had BXI, which is the law firm, a corporate entity, and you had Barnabas Ulu, the person. BXI was the first respondent, and Ulu himself was the fifth respondent.
Yes.
That's correct.
Yes.
Now, in respect of BXI, you convicted them of contempt, correct?
Yes.
Yes. Now, in your judgment, you say that even though the order that was imposed by Judge Rogers was an order for the payment of money, a contempt was still appropriate.
If I, without going to the specific paragraphs, there were 6 orders.
Yes.
I made a distinction also about,
Now let's just focus on the one order
Okay.
for now. That's the order that said they shouldn't allow the trust account to fall below a certain amount.
Yes.
They should keep 3.4 million rands in the account. Your judgment says that's an order sounding in money. But you say that even in respect of an order sounding in money, a contempt is still competent.
do you mind if I get to the page?
Yes, I can take you to the
Thank
page
you.
if you want. It is at paragraph 43, page 107.
Paragraph 43. All right, so that is where I dealt with the law insofar as the orders ad pecuniam solvendum.
Yes, that's an order for payment of
Ye-
money.
yes.
Now, that's the conclusion. Sorry, you want to say something else?
No, go
Yeah.
ahead,
Now,
sorry.
that's the conclusion I want to ask you about.
Yes,
Now, were you at that stage aware of the Kutsia judgment of 1995 of the Constitutional Court, which made it clear that under the common law, there is a distinction between an order for the performance of an act and an order for the payment of money? In an order for the payment of money, contempt is inappropriate.
I did not refer to I did refer to, is it Kutsia government versus government of the Republic of South Africa?
Yes. Well, let's forget about Kutia, that's long ago. Let's take Machabeng, which is a 2017 judgment.
Yes,
The local municipality, where at paragraph 56, it's made clear that the common law draws a sharp distinction between an order ad solvendam pecuniam, which related to the payment of money, and an order ad factum praestandum, which calls upon a person to perform a duty or refrain from an action. And then it says, a failure to comply with the order to pay money is not regarded as contempt in our law, whereas the disobedience of the latter order is. My problem is that you seem to have mixed these principles up.
At paragraph 43, Commissioner, and
Yes,
I'm not sure if
that's
this
where
is,
I am.
I'm not sure if this is responding to your question.
Yes, that's the paragraph I'm saying. It
Yes.
seems to me that it mixes the principles and doesn't refer to the correct authorities.
All right, and where I say I do not understand the common law rule to exclude a declaration of contempt, in brackets I say the civil remedy, where there is willful and mala fide non-compliance with an order for the payment of money.
Yes, exactly, and there's no footnote there. There's no authority at all. And the authority is in fact the opposite.
I referred to the Cape Times Limited versus Union Trades.
Yes, that's at footnote 64. And the actual correct authority is Machabeng, which is the Constitutional Court judgment of 2017. And Kutsia, Constitutional Court judgment of 1995.
Very well. I can only respond as follows. I take your point, firstly, and I've referred to Kutsia and Machabeng at footnote 61.
Yes.
I am aware, when I completed the application, I'm aware that I think leave to appeal was granted to the first respondent, the incorporation. I'm not sure what happened thereafter.
Yes, no, I'm
went
only
to this-
concerned about the contempt as
Sure.
against the company. I'm not interested in the contempt against the person. That's where these principles are being discussed.
I take your point, Commissioner. I can also say that, because I don't know what the petition was all about, I'm aware that there was a petition to the SCA, and the SCA granted leave to the company, to the incorporation.
Well, yes, sounds
Further-
sensible.
Yes, further than that, I can't, but I hear what you say. Thank you.
Can I ask you a second question about your grasp of the law of contempt? You see, the problem is that it's foundational to the constitutional system, as the Constitutional Court pointed out in the Zondo versus Zuma case,
Yes.
that you need to grasp the principles of the constitutional law. The other problem I have is paragraph 44, where you find on the preponderance of probabilities that the company is guilty of contempt. Whereas it seems that the law is that you must find beyond a reasonable doubt.
All right, then I'm going to, if I can go back in the judgment, where I deal with the legal principles, and I want to find that paragraph.
I'm at 44,
Yes.
it's page 107.
Yes, I'm going to the law which I set out from from paragraphs 18 on. And I just want to find the place so that I can respond to, oh, here we go. So I'm not sure if this is going to be of assistance. If I go to paragraph 21 of my judgment, and that's part of, that's the section that deals with the legal principles. I then deal with, if we go, I deal with considerations of the judgments Farkey, Feko, Birchall, and then I indicate there that the Constitutional Court in Machabeng clarified the position as follows. The standard of proof must be applied in accordance with the consequences of the remedies sought. If the relief applied for is a declaratory order, mandamus, structural interdict, or similar civil remedy, where the contemnor's right to freedom and security is not deprived, then the civil standard of proof on a balance of probabilities applies. And I refer there to, at footnote 30, Birchall versus Birchall. It's a 2005, I think it's Eastern Cape Division. And in the footnote I said, relief sought was committal to prison for failure to comply with a maintenance order. At paragraph 21, I go further and I say, with the civil contempt remedies of committal to prison or the imposition of a fine are sought, which impact on the contemptor's freedom and security of person, then the criminal standard beyond reasonable doubt applies.
Yes, no, I understand that. That's why I also went to look at your order to see if it was a mere declarator. And I found that your order actually imposes a fine on the company, which is a criminal sanction.
Then, and I'm going to stand corrected by you, Commissioner. I have no qualm being corrected because you've referred me to the cases, and then it must be that. Well, let me rather not jump to conclusions. My understanding is that the SCA then granted leave to the company.
No, I understand. I don't want to get into the leave
Sure.
issue. I just want to get your grasp of the principles of constitutional law. Because the distinction you seek, which is where declarator is sought, applying the standard of balance of probabilities may be appropriate, which is correct. But the problem with your judgment is that you actually imposed a criminal fine applying a civil standard. That's again the confusion I'm pointing to.
I can't argue then with you, Commissioner, on that. Yeah, I can't comment further. I will accept what you say.
Thank you, Tisri.
Commissioner,
Thank you very much. Good day, Magistrate.
Good afternoon,
Good afternoon.
Commissioner.
Thank you so much.
it is actually evening.
Almost evening.
my word.
Thanks. I'm going to be brief. You were a member of the Muslim Personal Law Working Group. Is that correct?
Yes, yes.
Do you still get consulted by the group, the Muslim Personal Law Working Group?
No, Commissioner, that was, if you go to the questionnaire, that was only in 2001.
Yes.
It was before I became a magistrate, and it was community work, if I could put it so. So the answer is no, because it was only for that period.
Let me refer to the period when you were a magistrate. Now, as a magistrate, have you ever been involved in a matter that implicates the Muslim personal law in the context of the strong human rights culture embodied in our Constitution?
I'm trying to think now. I don't think so.
You don't think so?
I don't think so. We get Muslim litigants daily, like we get litigants of all races and cultures and religions, but I have not myself been involved in a matter as a magistrate or regional magistrate where the question of Muslim personal law has been involved or has come before me.
Given that, how have our courts been able to manage the tension that exists between the human rights culture I've referred to and the Muslim personal law? Thanks.
I think if I can say the following in response. There's recently been a judgment, I think it was the end of June, by the Constitutional Court, and that judgment is the Women's Legal Center versus, I think, the President of South Africa, and that had to do with the Muslim marriages. So a Muslim marriage does not occur, how can I put this? A Muslim marriage occurs, there is a religious ceremony that happens. And up until that judgment, or at least until the SCA now, the Constitutional Court has confirmed, the Divorce Act and the Marriages Act, insofar as the definition of marriage is concerned, did not recognize a Muslim marriage in that definition. So we now have a judgment which, it doesn't open the doors for every Muslim husband or wife married in terms of Sharia law whose marriage is broken down to come to either the regional court or the high court for a divorce. It has very specific limitations. But what is important about that judgment, as far as constitutional rights and the recognition of Muslim marriages, is that we now have a judgment in terms of which certain sections of the Divorce Act and the Marriages Act has been declared unconstitutional because it excludes a Muslim marriage. And there is a period, I think it's 24 months, for the legislature to make the necessary amendments. But there is, at this stage, a limitation in that judgment, the orders in that judgment allows only specific categories of if I can call it Muslim litigants, to approach the courts. So for me, as a Muslim person, I think we've come a far way, because we now have a situation where hopefully soon we can have people who are married in terms of Sharia who can actually approach the High Court for a divorce and the regional court, because only the High Court and the regional court that can do divorces. And I think it's going to take a while yet, because we have at this stage that limitation in terms of those orders. And I look forward to actually hearing a matter like that, because I do a lot of divorces, and we get parties married by customary marriages. But Muslim people married in terms of Sharia, not in a court, not a civil marriage, have not been able to avail themselves. But now we have this, and I'm very happy.
No, thank you very much for that comment. Thanks, TCJ.
You did very well on the last question, Ms. Pangarker. For a textbook question that just came randomly. I sat in that matter at the SCA, so you got it.
Thank you.
Yeah, very right. Commissioners on the virtual platform?
I'm covered, Deputy Chief Justice. Thank you.
Thank you, Ms. Breitenbach.
Nothing from me, DCJ.
Commissioner Bernard?
No, I say nothing from me, DCJ.
Oh, thank you. Well, that brings us to the end of your interview, Ms. Pangarker. You're excused.
Thank you very much, Deputy Chief Justice and Judges, President and Commissioners. Thank you for your time.